Yes, good morning.
Good morning, my lord. By way of submitting my homework on the question of the requirement of availability to a buyer, may I offer two separate authorities. One is McGregor on damages, and one is a case in 1927 called Patrick and the Russia-British Grain. There's three there and there's three there. Thank you. And this is to support, in addition to
Just
my...
deal with this one first. Thank you very much. So the first is
A passage
McGregor.
from McGregor. Sorry, McGregor on damages.
Under the heading normal measure.
Yes, and the need for an available market. And the context here is my submission based on the Marine Star that the market had to be available to the buyer in question. And 26004, McGregor says that in the sentence that begins at the end of the third line, for to put themselves in such a position, the buyer must go into the market and buy equivalent goods. And that is the rationale for the rule, and that's a reference to the buyer. And then 26006, market price less contract price is laid down as the prima facie measure. I should say this is non-delivery, which is the closest, but the principles don't seem to change for non-acceptance. Mm-hmm. Only if there's an available market. The essential requirement is that the buyer should be able to go out and buy equivalent goods in the market. If the buyer can do this, then the court awards damages by way of the available market. If, on the other hand, there's a holding of no available market within the meaning of the subsection, the price can still be regarded as the market price, which is a wrinkle that we don't need. And then there's reference to a number of cases which I don't think we need to go into, including my lords in Air Studios. But the point is that the very rationale of the rule is that the buyer ought to be able to go in.
Well, no, it's the injured party. I mean, I don't think you can extrapolate from this, Mr. Berry, a general principle that it has to be this particular buyer or the market has to be available to him as opposed to somebody else. All that is being said is that the injured party, in order to put themselves in the position they would have been in, would have to go into the market and buy the goods. But
if he
that
can't,
answer the question.
But if he can't, then
there is no market. Possibly.
Right. No, well, there is a market, but it's not available.
Well, it doesn't deal with that scenario, nor does it deal with the scenario where there's no market.
Well, I accept if there's no market at all, then the market rule doesn't apply. But my submission, if there is a market, but in the circumstances of the breach, the buyer here, the non-recipient, can't access the market, then that is a no available market situation in my submission. That's my submission, what the buyer means here.
Okay, so that's McGregor.
And then there's Patrick.
Yeah.
And this was a case in 1927, subsequently approved, but briefly in the ARPAD by Lord Justice Scrutton, I should say. The buyer, merchants, bought Russian wheat of a certain description for delivery on a named date, and before the date resold the wheat at a profit. The sellers failed to deliver on the date, and subsequently there was no market for Russian wheat of the said description, and so the ratio is that there was no market. But it's obiter that I would seek to rely on at page 541 to the report.
Yeah.
In the second paragraph on the page, the first full paragraph of the page.
If there is a market available.
To the buyer.
Yeah.
No question of profit, loss of profit on resale can arise. And then in my submission, this is important. There are two classes of cases in which loss of a profit has been claimed, although there is a market, on the ground that the market is not available to the buyer. One is when the sale is of specific goods and the buyer has resold the same goods. And the other is where the contract of resale has the same delivery date as the contract of sale. Here, it is not necessary to consider either class since there was no market at all. So that's why I say it's obiter. And Lord, two things are clear from this in my submission. Firstly, the market has to be available to the buyer. It's not enough there is a market, it has to be available to the buyer. And secondly, one situation where it's not available to the buyer is that he has resold the specific goods. And the reason it's not available to the buyer in that situation is because he could not have, had the goods arrived, sold it at the market price. He was committed, they being the specific goods. And actually, and I fully confess I haven't put it as starkly as this before, but those are exactly our facts. There is no available market because the specific goods were resold on terms that therefore precluded access to the market. And it is only if you ignore the resale that there is an available market in the counterfactual. And the issue in this case is whether there is a rule of res inter alios acta which requires you to ignore the resale but in my submission there's no general rule that you ignore resales or that all resales must be ignored. It is not the relevant rule of remoteness or res inter alios acta is not that you must always ignore resales, because otherwise his lordship could not have said one case of loss of profit is where the sale of specific goods and the buyer has resold the same goods. By definition, you're taking into account the resale in deciding whether there's an available market. And I should just go forward to the RPAD so I can perhaps...
Isn't this simply an application of the primary rule in the Sale of Goods Act? So the estimated loss directly and naturally arising.
Yes.
And because there is no available market, you don't, the prima facie rule in subsection 3 doesn't help you.
Yes.
But you've still lost something.
Yes. Which has to be assessed on, well, if you've still lost something, it has to be assessed on normal principles.
Yes. Yeah.
But here you haven't lost anything.
But that's what were these goods worth to you? And in the sale of goods context, a resale value is as good as you can get.
Or, if you've resold them specifically, the specific resale price. In other words, yes, in a case of fungible, a sale of fungible, of generic, but not in a specific resale. So in a specific resale, you are your profit and loss, or your loss is calculated, taking into account the fact that you have that specific resale. But for present purposes, the point here is that there is no market available. You can claim loss of profit, although there is a market, on the ground that the market is not available to the buyer. And one of those examples is the resale. Now, obviously, that remoteness will come into cap, or remoteness may well come in to cap you if your sale is truly of a type that could not be foreseen. But where there is no available market, you get your provable actual loss subject to the usual rules. So here, because of the resale consisting of the MOAs, the effect of that is to make the higher market unavailable. My learned friend is entitled to claim his real loss of profit, which is nil. And the consequence of that, or put in terms of res inter alios acta, a resale of specific goods is not res inter alios acta. A resale of generic goods is res inter alios acta because you can, and therefore are treated as if you did, supply the subsale in the market. In a way, I apologise. I should have found this case before being prompted by Her Ladyship to look for available market cases, but it's actually in addressing the situation where there is a market but it's not available to the buyer, has actually provided in my submission a more direct answer to this case. And I rely on it as establishing that the res inter alios rule here does not exclude consideration of the subsale because it's a specific one. Just to go to the RPAD then, at tab 14 of the authorities bundle, it starts at page 157. And I won't go over what I submit are the obiter comments of Lord Justice Greer as to what the situation was in Rhoda Kanaki, and where he submitted on no basis that is apparent from the reports that it was he held it was a specific good sale. But the point about the RPAD at 157 is that it was a short delivery case, which is equivalent to loss of property, and the claim was brought in contract against the carrier, but also in conversion. The cause of action doesn't matter. The substance is that this is a Sanix Ace case, where what is being compensated, as we now understand things, is the loss to the property. And then the holding is at the bottom of the left-hand column at page 157, by Lords Justices Greer and Moore, Lord Justice Scrutton dissenting, that in estimating the damages payable by the ship owners for non-delivery, whether breach of contract or conversion, circumstances peculiar to the purchaser, such as a subsale by him, not communicated to the ship owners, must be excluded from consideration. In a proper case, the subsale might be used to their business value, ... and then after the colon, and that damages must be estimated without regard to that subsale. Now, 2 points to note, that the subsale here was a generic goods subsale. And that this was a conversion case. And for present purposes, the passage that my learned friend relies on is at page 165 of the bundle, but simply I submit that that is an unwarranted interpretation of Rhoda Kanaki. And I also submit that it was obiter to the decision, and if not obiter to the decision, not applicable to our situation, because ours is not a conversion type case or breach of contract amounting to conversion. But the passage I just want for present purposes to identify as 160 to 161 in the dissenting judgment of Lord Justice Scrutton, where he mentions, I don't say that it's a specific point, but he mentions at the left-hand column 161, in a passage about the measure of damages in contract and tort, he says, he's talking about the requirement for notice of a subcontract for it to affect damages, and then 5 lines down he says, an instance of the sort of notice required is where the plaintiff is known to be buying for resale, though he has not yet resold Lion and Fuchs, where the seller knew that the buyer was buying for resale, though he did not know of the contract for resale which the buyer afterwards made. Mr. Justice Rowland, there being no market, gave plaintiff the profit he lost by being able to perform the contract of resale. Mott and Muller is to the same effect, and the matter is fully discussed by Mr. Justice Salter in a careful judgment in Patrick and the Russo-British Export Grain Company, to which I refer. Now, it's probably fair to say that he was referring to the ratio there, but the point is that Salter is there cited as a careful judgment. It's obiter. This is obiter support for it, but I submit it reflects the correct rule. So may I then, having delivered my homework, go back to the authorities, and my submission was that the authorities support our formulation of the rule, which is that you do take into account a subsale or an on-sale of the specific goods, which means that the plaintiff in the counterfactual could not have accessed the market, which means that he suffered no loss. And but first, because of something my learned friend said yesterday, and which I reflected on overnight, is his submission that you cannot draw any analogies or inferences from cases about sale of goods, he says. Non-delivery, damaged delivery and sale of goods, even delayed delivery and sale of goods, to late delivery under a time charter, because they're different things. And that slightly nihilistic approach to principles we do not accept. And we do say that there is a set of underlying principles here, viz. The compensatory principle primarily, which require that principal decisions in different but analogous areas are applied to the new area that one is considering.
That presupposes that the areas are analogous.
Yes.
And it seems to me that one of the problems you're going to have to address is that in all the sale cases, when you're talking about the available market, it's the available market for buying or selling the goods.
Yes.
Here, you're saying that the market is the market for hiring out a profit-earning chattel. But the market for sale is something completely different. So the owners have put themselves out of the ability to go and buy another ship or use another ship to perform contracts or employ, because they've sold that particular good. But you're comparing a market for sale of ship, for buying and selling the ship, with a market for hiring the ship. And at the moment, it seems to me to be something of a mismatch.
Well, my lady, the way we analyse it is as follows. My learned friend is claiming for, we say the true nature of his claim is for loss of the opportunity to go into the higher market. He says it's violation of his proprietary rights.
You say that's the only thing he's lost?
Yes.
I'm interested in that.
Well, no, my lady, sorry.
If I don't have a ship, I can't use it for any purpose. It may well be that my primary use of this ship is to earn profits from it by chartering it out in the market. But can you realistically say that by not having that ship at a particular moment in time, the only thing I've lost is the ability to deploy it in that way?
Yes. The opportunity to employ it. Well,
as my lord put to you yesterday, you could take it on a Mediterranean cruise, you could put it into dry dock, you could do anything with it.
But those are, if I might, those are actual decisions of that nature, may or may not be relevant to the question of causation and remoteness. But to answer your ladyship's primary question, the true nature of my learned friend's claim in my submission is, and we saw those submissions yesterday, loss of opportunity in the higher market. Now, it is possible that there are other losses involved, and in this particular case, there definitely was one other loss involved, which is 2 days' interest on the delay in receiving the purchase price under the MOAs. So I'm not saying that there is no other.
That may have been. I don't think the facts, because that claim wasn't made, I don't think the facts actually spell that out, that loss was suffered.
They don't.
But it might have been.
It might have been, yes. I mean, looking at the terms of the MOA, there there was no breach of the MOA by the 2 and the 7 days delay, but obviously the price was payable by reference to the notice of readiness under the MOA in the usual way. And so there would be an inference of normal loss, to use one of my learned friends' phrases, of loss of interest. So when I said to my lady, there's no other benefit, I was overstating it. But relevant to this case, there's no other benefit of this ship than earning hire, because that is the nature of his claim. He wants the hire. He wants the market rate of hire.
We're going back to first principles, as you say, and therefore the principle that you are applying must apply across the board to all cases, not depend on the way in which the owners in this case have put their case against you. So it has to be said that generically, whenever you have a case for late redelivery under a time charter, what the owner plans to do with this ship is relevant. That's what it has to be.
No, irrelevant.
Well,
What
no,
he's lawfully allowed to do with ship.
Relevant because you say it's relevant to look into the fact that he sold it.
Yes, but not because that reflects his intention, but because that sale occurring before breach disables him legally from any other use. It's not a question of intent, or it's not a question of what choice he would have made amongst a series of legally possible options. I accept that if he has a choice of legally possible options, it is not open to a defendant to say he would, in the event, afterwards have chosen that. It is a question of legal rights. He has not the legal right to do anything with this ship other than deliver it onto the MOA, which is what he did. And in the counterfactual, one is valuing his legal rights, if one is valuing his legal rights do not include dry docking it, sending it on a...
He could have chosen to break his contract with the buyer. What then?
My lord, there's another, in my submission, there's another principle, which is that one is presumed to perform one's contracts, and if one breaks his contract, then he will be liable in damages for that. And in this case...
Maybe not. The buyer, for whatever reason, might not have suffered damages. We don't know.
But he is also likely to be vulnerable to a claim for specific performance for a ship. But my lord, in assessing damages, my submission is that one does not take into account the possibility of acting unlawfully. Because acting unlawfully is A, breaks the chain of causation, and B, is too remote. So one is valuing, one way of putting it is one is valuing the...
You might have done a deal with the buyer to be given the high market for short-term parties to put it off for a month or two.
That would break the chain of causation. Not insisting on your legal rights and doing a deal.
As no doubt you would say if the buyer changed his mind and said he didn't want the ship after all.
Yes. All of those things are matters of causation, my lord, which may or may not happen, but if they did happen, would be tested on the doctrine of proximate cause. But that doesn't affect the proposition that as at the date of breach, my submission is that he had no legal right to do anything but what he did. And if he acts better than or not so good as his legal rights, that would break the chain of causation. So, for present purposes, it is the difference between legal right and prediction of what course amongst a selection of possible legal rights he would have taken. The latter does not come into it. It's the valuation of his legal rights that does come into it. And once again, it follows from the Salter problem of the specific subsale, and in my submission from the authorities, which is that where there is a specific goods subsale that is taken into account, and it's taken into account That's the res inter rule, and it is taken into account because it deprives you of the opportunity of going into the market. Or to put much more simply, in the terms of Robinson and Harman, damages to put the plaintiff in the position he would have enjoyed had the contract been performed. Now, unless you ignore the MOA, if this contract had been performed on its terms, then except for the possibility of 2 days' interest, the claimants would be in exactly the same position in that counterfactual as they were in the factual. And I come back to that fundamental rule, which in my submission has been broken, would be broken by my learned friend's submissions here. He is better off, if my learned friend is right, he is better off by the breach of contract than had the contract been performed. And you've got to find some very good reason for achieving that result. And that's almost exactly the words of Lord Atkinson in Wertheim, which I'll come to in a minute, approved by Lord Scott in the Golden Victory. Thank you. But to go back to the point of authorities, so I do submit that this case is analogous to the sale of goods cases, because this is a case of delay in receiving back the contractual right of exploiting your own ship. And although it's receiving back a right of exploitation of goods, that is analogous to delay in receiving goods. Not the same, because it's not a proprietary violation, but economically analogous. Sale of goods are economically analogous to delay in receiving back the unfettered contractual usage of your ship. And also because the underlying reasoning is transferable. The basic reasoning is Robinson and Harman, damages that put you in the position as if the contract had been performed. Are there any reasons to depart from that principle by ignoring part of what would have happened in the counterfactual? But if my learned friend's nihilistic approach is accepted, and one can't analogize from other areas, then I'm afraid to say he has thrown his own baby out with my bathwater, because his rule is derived from Rhodo Kanaki. And if there's one thing that in my submission is clear, is that Rhodo Kanaki is considerably less analogous than sale of goods, because Rhodo Kanaki, like the ARPAD, is a claim where the breach of contract is the same as the conversion, and where we know from the Sanix Ace that the compensatory principle is different. The one place you cannot analogize from are claims against carriers for loss of or damage to goods. And yet that is what my learned friend does. So the analogies I offer are closer than the analogies he offers. But let's take the utterly nihilistic position and say none of these authorities impact on the question at all. Then in my submission, one is left with the basic compensatory rule. Put him in the position as if the contract had been performed. So all authority is irrelevant because it's all different, leads us into the position where you simply apply the compensatory rule. He's got to find a rule from somewhere that disapplies the basic Robinson and Harman rule. Now, I accept that by analogy from sale of goods cases, which themselves analogize from Rhodo Kanaki, well, I submit that there is an exception, and that is where there is a subcontract, but the subcontract is performable in the market. But the reason why you disregard that is because it's irrelevant, because it could be performed in the market. And that is no such exception applicable to contracts which could not be solved in the market, with the consequent result that the plaintiff was not able to access the market that he claims on the basis of. My learned friend is claiming the market rate of hire in the hire market. And we say he could never have got that, both because of the mere fact of a subsale of the specific good, and also because the subsale had a contract saying thou shalt not access that market. So on the Salter case, and because it is not a resident alias actor, that's that point. If you strip away all authority, then just apply the compensatory principle in my submission of Rhoda Kanaki. Now, can I just then, with that preface as to the use of authority, go back to the authorities and start again with Rhoda Kanaki? I think I was being a bit slow yesterday, and would like just to go back to a passage that my Lord Justice Mayles referred to, and this is on the question about whether it was a contract, the subsale was a contract for the sale of the self-same goods. And my Lord referred me to something, and I'm afraid I didn't pick it up exactly, but it's at page 24 of the bundle, page 76 of the report. And in the passage of Lord Isha, these considerations determine the question of liability, but then there's the question of damages. I think that the rule as to the measure of damages in a case of this kind must be, the measure is the difference between the position of the plaintiff if the goods had been safely delivered and his position if the goods are lost. And we entirely endorse that. That's a statement of the general principle. And of course, simple application of that means there's no loss. What then is that difference? If the goods are delivered, he obtains them, but in order to obtain them, he must pay the freight. Okay, well, don't worry about that. If there were no lien, don't worry about that. Upon getting the goods, he could sell them. So that presupposes that in the case of this nature, you can sell the goods upon getting them in the market. And so whether or not, whatever or not the facts of the subsale were, the hypothesis or the basis for Lord Isha's reasoning is the subsale is not of the specific goods, because if it were, he could not sell them. He would therefore get the value of the goods upon their arrival at the port of discharge, less the lien. So that certainly implies, and in a way it doesn't matter what the true fact is, it's the theoretical reasoning, it's the reasoning that matters. And the reasoning underlying this case is he could have sold the main contract goods, notwithstanding the subsale. Therefore, the subsale must, in a case of this nature, have been of generic goods, satisfiable.
Yes, I was referring to that, questioning whether that was consistent with Lord Justice Greer's understanding of the case in the RPAD.
Yes, and I'm now agreeing, rather, having not spotted that was what followed from your Lordship's point. I'm saying that
Yes, I see.
that is A, inconsistent with Lord Justice Greer in the RPAD, but B, more importantly, that is the whole hypothetical or rational substructure of his Lordship's decision. This decision only works if it is hypothesized on a subsale of generic goods. So, Rhoda Kanaki, for two reasons, doesn't assist. Firstly, because it's damages for loss of property, but secondly, because it's a case of a generic subsale. In our case, there's no property damage or loss, and the subsale is for the specific goods. Can I then take you to Wertheim, which is Authorities Bundle 6, page 58. And this is delay in delivery of goods which were delivered late but accepted. And there was no claim or no liability on the subsale, if I can call it that, for damages. The head note, page 58 of the report, again reiterates the general principle. The general intention of the law is that the plaintiff should be placed in the same position as he would have been if the contract had been performed. In the case of late delivery, the measure, in order to indemnify the purchaser, is the difference between the market price at the respective dates of actual delivery of the goods purchased, but if the purchaser resold them at a price in excess of that prevailing at that date of delivery, he must, in estimating damages, give credit therefore. And then the facts were that there was a contract to deliver 3,000 tonnes of moist wood pulp between September and November 1st of 1900, and the appellant claimed to recover 27 shillings and 6 a tonne, the difference between 70, the market price on the due date, and 42 and 6, the market price at the same place on the date of actual delivery. But it appeared that he had sold the goods at 65 a tonne, involving a loss to him of only 5 shillings. And it is apparent, and I think it needs to be just recorded here from page 63 of the bundle, 306 of the report, that those 60 shilling subsales predated delivery, predated the breach, in other words, and you see that from the middle of 306. The appellant, in reality, never sustained this loss nor anything like it, because he sold the goods under contract, some anterior to the date to the contract suit on, so some even before he bought them, and the others anterior to the date of actual delivery at the price of 65. So this is a case of pre-existing sub-sales, and the contract does not, again, the report doesn't specify whether it was generic or specific goods, but at least at that stage, subject to appropriations, it must have been generic. And therefore, he only suffered a loss of 5 shillings in reality, on the hypothesis that they were generic subsales, because he actually sold them for 65, and had they arrived on time, he could have got 70.
Could I venture to suggest that you don't need to be a shipping lawyer to find the result in this case unsurprising?
And, my lord, you don't need to be a shipping lawyer to find the result that my learned friend is contending for in this court surprising.
Well, that's a different...
Because he actually sold them on. It's the same point.
But he didn't. But you're comparing hire with sale again. You see, if you look at Lord Atkinson on page 65, he's talking about what the goods are worth to the purchaser.
Yeah.
And what the goods are worth. What the ship is worth is different from what the goods are worth.
Well,
You're not selling the ship.
well,
It's not a case of a late delay in delivery of a ship under a ship sale contract.
no, but it's the underlying principle. And in this case, my lady, my learned friend is claiming the market rate of hire in the hire market, in circumstances where he could not have got that in the in the counterfactual because of a sale in a different market, the MOA.
Let's transpose Lord Atkinson. Similarly, when the delivery of a ship chartered to a time charterer is delayed, the ship is presumed to be, at the time that it should have been delivered, worth to the ship owner what he could hire it for, or there, where does the analogy go? Because he wouldn't be going out and hiring another ship in the open market.
The analogy goes, the answer in this case, I accept that test, and the analogy goes, it's worth nothing to him because he can't hire it.
Ah, no, there's a presumption. I'm just looking at Lord Atkinson. The goods are presumed to be worth to the purchaser what he could hire them for.
Yes.
And they're presumed to be, and then he talks about the presumption being rebutted.
Yes, so they're presumed to be...
If he had hired it out at a rate that was higher, then maybe he'd have to bring that into credit, but it doesn't say anything about selling it.
But the ship is presumed to be worth to my learned friend's clients what they could have hired it out for, which is nil because they couldn't.
Well, that means that you are saying that the presumption is to be rebutted in some way, but at the moment...
No.
That's
No.
eliding the two stages of the analysis.
With respect, not. I'm saying the presumption doesn't. I'm saying the presumption leads to nil because it invokes the question: what could he have hired it for?
Doesn't this still come up against the issue that this logic would seem to apply, let's say the logic of Lord Atkinson would seem to apply, if, in fact, the ship owner has fixed his ship for a follow-on fixture a month earlier at a much lower rate of hire. But you accept in those circumstances that the damages would be by reference to the market rate at the time of redelivery and not the actual loss which he has suffered, which is a different rate.
Did I say, if he'd hired it at a rate that was higher, he would have suffered an actual higher loss, which would be reduced by mitigation. If he suffered it actually lower, if he'd prefixed it at a lower rate, I think my submission would be that that's his actual loss, and he would be confined to that.
Oh, that's different from what you said yesterday, I think.
If so, then I misspoke yesterday, I think.
So
I was considering the higher.
All the cases which talk about the market rate at the time of redelivery for a short overrun period are therefore wrong because they have failed to take account of the way in which this business actually operates, which is that people don't wait until they get their ship back to go into the market.
They go, but I don't think there's a case in which there was a pre-existing, well, I stand corrected, but I don't think the question has arisen where the pre-existing...
No, I think you're right.
The forward fixture was lower.
None of the cases discuss the fact that, in fact, ship owners do not wait until the day of redelivery to go into the market. But it cannot be the case, surely, that the very experienced judges who dealt with these cases wouldn't have been aware of that.
Well, only if the parties had departed from the convention of assuming that whenever you did prefix, you got was the market rate, as it were. In other words, there seems to be a sort of Mexicans a standoff whereby nobody's ever investigated the difference between the fact that you actually prefix, and maybe you don't prefix that far in advance. I mean, I know bareboat charters sometimes take a month to negotiate, but short-term fixtures are much more short-term, and usually only when the redelivery notices are given, 15, 7. So in practical terms, my answer to your lordship is that in practical terms, the point may never have arisen because in short-term business, well, the redelivery notice is sometimes 30 days, but it's usually 15, 7, 4, whatever, and you fix in a week. So in practical terms, the Cargill case may be different, but in practical terms, a long forward prefixture may be an unusual thing, which may be why the issue that your lordship now raises has not been presented to judges, and judges only deal with issues that are presented to them, if I can put it that way. So, yes, there may be an unprecedented, it may be that if there's a pre-fixture of a month or more in advance, a pre-forward fixture, at what turns out to be significantly lower than the market rate, that new case, in my submission, would be determined in the same way as this case. If it were the other way around, then there would be remoteness as well. And that case, no, that case has not arisen as far as the law reports show. But the reason for that is not that everyone's always awarded and assumed an award of the market rate damages, notwithstanding a forward fixture at a lower rate. It's because it's never arisen. Parties seem to have taken the practical approach that it's fixed close enough to the redelivery date that the market will not be different.
Okay, thank you.
So I don't think inference can be drawn from the absence of it. Because if there was a decision about it, we wouldn't be here, or we would say analogously. And indeed, I think it's accepted that the point now has not arisen in its exact form before, and that may be because of the general, or a general rule of thumb approach that you assume that the prefixture was sufficiently close to the redelivery date as to be in the same market. And practically speaking, it's only extremely unusual events like wars that will effect a significant change in a market in a sort of period of... I'm giving evidence here, I should stop. So Lord Atkinson, at page 61, starts, and I don't think we need to go into the facts, but to the principle, and perhaps we can look at the bundle 64, page 63. At the bottom of page 63, perhaps I can start with the that, however, is not the only peculiarity in the appellant's claim, and this is I mean, let me start a little bit earlier. Yet so rigid, it is insisted, is this formula or rule that resales must be ignored as collateral and irrelevant matters, and damages be awarded for a loss in reality has never been sustained. Now, that is my learned friend's submission here. That, however, is not the only peculiarity of the claim, and then he talks about the peculiarity of the difference between Chicoutimi and Manchester and the like. And then a couple of lines further down, if the pulp had been delivered in November and the appellant had sold it then at the highest market price, namely 70, he would have made a profit of 32. But if the appellant was to succeed in this action, he would have received from the sub-vendee the price at which the goods were actually sold, namely 65, plus 27 per tonne from the respondent in the shape of damages, making together 92 a tonne, leaving a profit of 54 per tonne, or 22.6 more than if the contract had never been broken at all. Now, the figures adjusted slightly, and the incidence of the phrases is adjusted slightly, but the principle is the same. He is claiming, my learned friend is claiming damages which would give him more than if the contract had never been broken at all. And over the page, his lordship says, one cannot but feel that the reasoning which leads to results so unjust and anomalous must be fallacious. Now, my Lord Justice Coulson said, well, it's not surprising, but the not surprising part of it is that the damages claim would give the plaintiff more than if the contract had been performed. That's what's so unjust and anomalous about this claim against my client. And then he goes on, in effect, I won't read it all, but he goes on, in effect, to say you must take into account the subsale. It's the general intention of the law in the middle of the page that in giving damages for breach of contract, the party complained should, so far as can be done by money, be placed in the same position as he would have been in the contract been performed. The usual rule. This is a ruling proposition. It is a just principle. The rule which prescribes as a measure of damage the difference between market at the respective times above mentioned is merely designed to apply this principle, and as stated in one of the American cases cited, generally secures a complete indemnity to the purchaser, but it is designed to secure only indemnity. It's presumed to be the true value. In the case of non-delivery where the purchaser does not get the goods purchased, he assumed that these would be worth to him if he had them what they would fetch in the open market, and that if he wanted to get others instead, he could obtain them in that market at that price. And he goes on to say at the bottom, in such a case, the price is properly treated when no question of loss of profits arose as an entirely irrelevant matter. So Rhoda Kanaki, so here's a sale of goods case, and I'm judging from Rhoda Kanaki, and he says that he doesn't say Rhoda Kanaki is wrong, and then he goes perhaps near the first hole in the page, but if in fact the purchaser, when he obtains possession of the goods, sells them. Now, I've already made the point that these were under pre-sale, contracts of sale made previously, so sells there means delivers under a contract at a price greatly in advance of the then market value. That presumption is rebutted, and the real value of the goods to him is proved by the very fact of this sale to be more than the market value, and the loss he sustains must be measured by that price, unless he is against all justice to be permitted to make a profit by the breach of contract, to be compensated for a loss he never suffered, and be put as far as money can do it, not in the same position in which he would have been if the contract were performed, but in a much better position. And that is the rule, and this is authority for the proposition in my submission that in a case of delay to goods, which is analogous to delay in restoring the contractual use of your ship, it's analogous, and you do not ignore subcontracts. Now, the effect of the subcontract there was to it was actually performed, and it avoided the loss in the factual. But the principle is the same if the effect of the subcontract is to prevent the earning of the hire in the counterfactual. Those are just factual incidences of the question, what would have happened if the contract had been performed. And can I just show you what was said about this in the Golden Victory, which is tab 32 and page 497 of the bundle in the judgment of Lord Justice Scott, Lord Scott, to show that this part of Wertheim has been endorsed. We'll see, it was endorsed in Williams and Agios, and it was endorsed by Lord Scott for the majority in the Golden Victory. He cites at the letter C at page 497.
Page
497 of the bundle, 380 of the report.
497. Yeah.
And they're talking about predestined events here, so that is a different case, because in our case it's a question of pre-existing contracts. But if it can be shown that those events were at the date of acceptance of the period predestined to happen, the damages which the claimant can recover are not more than the true value, if any, of the rights which he has lost having regard to predestined events. Now, we're not predestined events, but we are pre-contractual. We are dealing with existing contracts, but in my submission, a fortiori. Another way of making the point put by Lord Justice McGaw is that the claimant is entitled to the benefit expressed in money of the contractual rights he has lost, but not to the benefit of more valuable contractual rights than those he has lost. In Wertheim, Lord Atkinson referred to the general intention of the law, and so on. We've had that quoted. And in relation to claim by a purchaser for damages for late redelivery of goods, where the purchaser had after the late redelivery sold the goods for a higher price, he said, and then I quote, so those passages have been endorsed in the context of repudiation of a time charter, which is somewhat analogous, as a general rule. So, in my submission, I'm going to say Wertheim should be followed as such, but it's been subject to criticism. So perhaps I can go next to Williams and Agios, or Agios, in tab 8 of the authorities bundle. And in this case, one sees from page 83 of the bundle,
Was Lord Scott the only person who discussed
No,
at that time?
he wasn't. I think others
did.
others refer to it with sort of more general approval, I think, but I'll better show you that.
Lord Bingham, page 490.
Yeah. Yes, my lady's right, and there are other references which I was supplied with, but thought that Lord Bingham was dissentient here.
Yes.
But he says Wertheim was not a case of
More
non-delivery.
recently, the Supreme Court tends to cite Lord Bingham more than it does Lord Scott.
Yes.
It does, save where he is dissentient as he was here, which is why I chose Lord Scott.
No, it tends to cite Lord Bingham in the Golden Victory.
Oh, I see. Sorry.
Particularly when Lord Hamlin is giving the judgment.
Right. In that case, I better read and make submissions about this passage. I see. Sorry. That time was not a case of non-delivery or refusal to deliver, not of delayed delivery. And once again, by the way, in answer to a point made by my learned friend, here's another case of rules in shipping cases being decided by analogies with sale cases, where analogous. The goods are delivered late were received and there was no accepted repudiation. The case would not have fallen under 51.3. The buyer made a claim for damages based on the difference between the market price and the place of delivery. At the place of delivery when the goods should have been, that's the 70, and the market price when they were in fact delivered, that's the 42. It was apparent on the figures that this claim, if successful, would have yielded the plaintiff a much larger profit than if the contract had not been broken and he was compensated for his actual loss. None of these cases involves the accepted repudiation of a commercial contract, such as a charter party. So he distinguishes it on the basis of it's not a repudiation case, but then nor is our case a repudiation case. And otherwise, he cites it with at least implicit approval of the principle. You award the actual loss if in the subcontract if you recovered under the subcontract. And I think I should also look at Lord Carswell, since the question was asked at page 506. Where he said in paragraph 57 of the judgment, damages for breach of contract are compensation to the claimant for the loss of his bargain. He's entitled to be placed, so far as money can do it, in the position which he would have occupied if the contract had been performed. See Wertheim 307 by Lord Atkinson, and that's a reference to one of the passages that we identify. And then he says, he talks about the basic rule in repudiation of the charter party between B and C, and the calculations made on the basis that injured party can mitigate by going into the market and obtaining a replacement charter as soon as reasonably possible. So certainly in the case of a repudiation of a time charter, it's loss of the opportunity to go into the market that's been compensated. And so also I would submit by analogy late redelivery. And then that's the element amico. His loss will then be calculated by reference to the extent to which he is worse off in consequence. That will normally be the extra cost of chartering a substitute in the case of repudiation. And I don't think Lord Brown explicitly mentioned the Wertheim.
So you can say then that it was referred to by a number of judges with perhaps varying degrees of enthusiasm, but nobody seems to have said it was wrong.
I would say they were all. I would say they all regarded it as right without discussing it, but Lord Scott in particular said it was right.
Yeah. Okay. Thank you.
Lord, just to complete it, Lord Carswell deals with it at the top of page 506.
Yeah, we'll just...
Yeah. What was that?
Yes.
Yeah.
Funnily enough, he analyses it in terms of mitigating the loss by going into the market and obtaining a replacement charter.
The way I would analyse that,
Amico.
the way I'd analyse that, my lady, is that it's prospective, presumed mitigation rather than actual.
Yes.
Yeah. and you get damages on the basis that that's what you ought to do, as it were, or what would normally be done. Williams and Agios 8. So the thing to notice about this is that the contract and the subcontract were for goods by description, and the subcontracts were at a higher price. So this is, in my submission, a case about remoteness. A loss was suffered because of the loss of the subcontract at the higher price. The question was, could he get that? And to make that good, so Agios contracted to sell to Williams a cargo of coals to be shipped in November 11 at the price of 16.3 on CIF terms. And so that's generic goods, coals to be shipped. Arbitration clause. Then in the fifth line, in October 11, W agreed to sell to G of Turin a cargo of coals of the same amount and description, so sale by description, at 19. In November, G sold back to A, so it's a circle, the cargo he had bought from W at 20, and ceded to A all his rights and liabilities under his contract with W. So that's a complication. At the date of the breach, the market price of the coal was 23.6. The dispute risen between W and A whether the measure of damages in respect of the non-delivery was the difference between 16 and the market price of 23, or the difference between the contract price and the price at which W sold to G, the 19. The matter was referred to arbitration. Under the terms of the contract, the arbitrator found that W intended to resell to G the cargo due to him A, and appropriated that cargo, gave his award in the form of a special case. The arbitrator had no jurisdiction to deal with that, and the true measure of damages was the difference between the contract price and the market price at the time of the date of breach. At that time of the breach, Rhoda Kanaki approved in a sale case, and Lord Dunedin said, in the question of measure of damages in respect of a breach of contract, there is a distinction between non-delivery and delayed delivery. And so, insofar as that distinction applies, we are the delayed and the non. Now, I think what one could look at some of the other judgments, but I think perhaps Lord Dunedin is the one that's generally cited, and he starts at page 94 and goes from 95 to 96 of the bundle. And he has this is the principle. One could read it all for context. It was, however, argued at your lordship's bar that Rhoda Kanaki was wrongly decided, and it was said to be in conflict with the principles laid down in the recent case before the Privy Council of Wertheim. It is certain that Lord Atkinson, who delivered the judgment in that case, did not think that he was going against Rhoda Kanaki, for he says so in terms. Nor, in my mind, is there any discrepancy between the two judgments. Wertheim's case was a case not of delivery withheld, but of delivery delayed. The buyer therefore got the goods, and the only damage he suffered was in delay. Now, delay might have prejudiced him, but the amount of prejudice was no longer a matter of speculation. It had been put to the test by the goods being actually sold. And he was rightly, as I think, only held entitled to recover the difference between the market price at the date of due delivery and the price he actually got. But where there is no delivery, the position is quite different. So, in my submission, that is House of Lords authority from Lord Dunedin, and he's generally regarded as representing the principle in this case, that Wertheim is good law for delivery cases, for delay cases. And over the page, at 96, we have the passage that was cited by Lord Justice Stratton in Slater and is relied on, I think, by my learned friend. And he says, the truth is that the respondent's argument leaves them in a dilemma. either the subsale was of the identical article, and let's pass over that because that doesn't apply to other case. If, on the other hand, the subsale is of the self-same thing or things as is or are the subject of the principal sale, then ex hypothesi the default of the seller in the original sale is going to bring about an enforced default on the part of the original buyer and subsequent seller. Now pause there. The first submission I make on that is that that is not true of a delay case, as in this case and as in Wertheim. It's only if it's a sale of the identical thing and on identical dates. But Wertheim was not such a case, or it doesn't, we don't know, but it doesn't seem to have been such a case, and nor is ours. So the ex hypothesi doesn't apply to our case at all. And how can it ever be known that damages recoverable under that contract will be calculable in precisely the same way as in the original contract? All that will depend on what the sub-buyer will be able to make out. The only safe plan, therefore, is in the original contract to take the difference of the market price as the measure of damages and to leave the subcontract and breach thereof to be worked out by those who it directly concerns. Now, in my submission, that is, firstly, not applicable to a delay case. Secondly, there is an answer to the rhetorical question, as the learned judge below here said. How can it ever be known? Well, the answer is you just look at the subcontract. Easy. And thirdly, this, in my submission, is hypothesized on the assumption that what is being claimed is damages for breach of the subcontract. And this may be a valid dictum against allowing that sort of claim, but not a reason for disregarding a subcontract if it obviates all loss. And finally, in my submission, this was a case of remoteness, not causation. And when he says you can take, the only safe plan is to take the difference, what he is saying is you cannot recover other than the difference in a case where in fact you suffered a greater loss because we saw the subcontract prices were higher. And if that's not exactly what he says what he says in the context that that was the claim for extra profit on a subcontract, on the basis of a subcontract. That is not authority in my submission for a rule that you ignore a subcontract which means that no loss was suffered. And indeed, his endorsement of the general principle in Wertheim indicates that he cannot have been meaning that. Because he said it's valid to look at the subcontract in Wertheim. Previous to the page, in Wertheim's case, delivery delayed, the buyer got the goods, and the only damage he suffered was in the delay. Now, the delay might have prejudiced him, but the amount of prejudice was no longer a matter of speculation. So here, the delay might have prejudiced my learned friend's client. This is the middle of page 95. But that's no longer a matter of speculation, because we know it didn't prejudice him. So, in my submission, Agios is support, another House of Lords support for the correctness of Wertheim as a matter of authority, but also as a matter of principle, that you do, because of the basic compensatory principle, take into account a subsale that fixes, that takes out of the realm of speculation and fixes what was actually suffered. In this case, we submit nothing. Then Slater, my submissions on Slater, which are in the authorities bundle at tab 11, this is the case in which Lord Justice Scrutton, as explained by Professor Tritle, actually explains what's going on in this area, rightly.
Sorry, he performs what?
This case explains what's going. When I say what's going on, I mean the true basis for the rule of res inter alios acta in this area.
Right, so the true basis of res inter alios acta.
In this area, and by this area I mean subsales, onward sales, other contracts dealing with the goods.
Yeah.
I hope I made plain yesterday that res inter alios act is used for a wide range of other things, but properly so called in the context of this case, it is res inter alios act as far as relates to the treatment of subcontracts. And the point about this case was that there was a sale and an on sale, and interestingly enough, a bit like an Oxbridge tutor, one of the subsales was below and one of the subsales was above what turned out to be the market price. And the actual decision was the subsales were irrelevant, and it was purely the market price, so they were irrelevant to reduce or increase the damages, this being a case of generic goods. So those are briefly the facts. Can I then, and the judge below says that Lord Justice Scrutton differed from the other two, but with respect, we don't think that's an entirely correct analysis. We say that they, in substance, made the same ruling, but Lord Justice Scrutton explained it more fully. So can I first then invite you to look at Lord Justice Banks at page 117 of the bundle. So he started by saying that they approve and apply Rhoda Kanaki, and that's the ratio of this case in a case of subsales of not the same specific goods. The claimed vert time was for delay. Lord Dunedin in Williams approves the decision in vert time and distinguishes it from Rhoda Kanaki's case upon the ground that in the one case the buyer got the goods and was only claiming damage for delay, whereas in the other he never got the goods at all. So that's Court of Appeal authority endorsing House of Lords authority explaining the difference. And this is the ratio in my submission of Lord Justice Banks' distinguishment of vert time in his present case. Lord Atkinson expressly says that Rhoda Kanaki case was, of course, no reference whatever to the case of late delivery of goods, as is from non-delivery, and then he refers to the general rules, and then he says, I do not think that the decision vert time can be extended to apply to the case where damages are claimed for breach of warranty of quality, not necessarily decide the point, ... And there was an issue of bleaching there, which is ultimately doesn't affect the points principle. If the rule laid down in Wertheim's case is ever to be applied in a case like the present, it can only be so applied where the subsale relied on in mitigation of damages is a sale of the identical article, which was the subject of what Lord Dunedin speaks of as the principal sale, made clear by a passage of Lord Dunedin in that case, which is the passage that I've read from you in 96. So the ratio, if I may put it, of Banks is I apply Rhoda Kanaki. Wertheim doesn't apply because it's delay, not damages. And in a damages case, it would be justified if it were a specific subsale, but not if it were a generic one. And I rely on all three of those rationes of Lord Justice Banks. In particular, if it is ever to be applied, I interpret, perhaps over-interpret, as it should be so applied in such a case. And in a case where there's a specific subsale, then it should be applied even to damage cases as well as delay cases. Now, Lord Justice Warrington starts at 117, and he delivers his ratio in my submission at 119 to 120. Halfway down page 119, Lord Justice Warrington says the defendants rely on the rule laid down in Rhoda Kanaki, and then he quotes it. And then in the bottom part of the page is an indeed about 8 lines up. Indeeds, on the facts of the case, there are special reasons against doing so. The subcontracts were not for the identical goods. This is our own case. So the Slater case was not identical goods, and they might or might not be performed by delivering goods in the subject of the head contract. The decision in Rhoda Kanaki was followed in the House of Lords in Williams, but it is said that the present case is governed by Wertheim. That was an action for delayed delivery of goods. The purchaser sold, and the price exceeding the prevailing point of delivery, and it was held that the higher price to obtain must be substituted for the lower one as one of the elements of comparison. I do not think this case is governed by Wertheim's case. The purchaser has received inferior goods of smaller value than those he ought to have received. He lost the difference in the two values, and it seems to me immaterial that by some good fortune, with which the plaintiff has nothing to do, he has been able to recoup himself for what he paid for the goods. If the goods had been of the quality contracted, he might have sold them at a higher price, so there again it's a generic good case, and made a profit. In truth, as I have already pointed out, the class of case we are dealing with, the contract price does not directly enter into this calculation at all. Now, reading that, in my submission, the ratio is that Wertheim is to be distinguished because it's delay, not damaged goods. So that's a majority for that distinction of Wertheim. And also, the real ratio of his decision is that Rodokanaki applies in a case where the subsale is of generic goods, not identicals. And then Lord Justice Scrutton personally desired to reserve judgment because the question of the measure of damages is of some general importance, and I echo that submission in this case. And perhaps at a passage that my learned friend helpfully showed at page 123 of the bundle, 20 of the report. Perhaps just past halfway down, it is well settled, and pose the question, that damages for non-delivery or delay where there is a market price do not include the damages for loss of any particular contract. He means subcontract, unless that subcontract has been in contemplation, and this is not a contemplation case. The value of the goods in the market, independently of any circumstance peculiar to be taken, the plaintiff is to be taken. So he's explaining the market value, what underlies the market rule. If the plaintiff has a profitable contract to sell the goods and there is a market, he can supply himself with the goods by purchasing in the market, i.e. he can perform the subcontract by going into the market. So therefore he gets the market rate, and the actual subcontract rate is irrelevant. And he's then left without the goods that he should have received under the original contract and has lost their market value. But suppose he's subcontracted as a price below instead of above the market price, so that if he delivers goods under the subcontract, he loses. Can his damages be limited by the amount that he would have received on the subcontract? On the above reasoning, it would seem not. He could supply the subcontract by buying in the market, and then should have goods delivered to him of a certain market value, which he has lost because they were not delivered. This has been decided in the case of non-delivery of goods by Rodokanaki and by the House of Lords in Williams and Agios, where Rodokanaki was approved. So the reason why the subcontract doesn't increase or reduce your damages is because the subcontract can and therefore should be supplied from the market. And that's why you get the market rate. And that is the res inter alios acta rule in this area. That and no more than that. Now, he goes on to explain Rodokanaki, and I accept he didn't explain it as I do in my first explanation, that it was a loss of goods and therefore one was compensating something different. But I submit that is how Rodokanaki would now be explained. But he explains it on the basis that it was a contract for similar goods subject to the market rule above. As in Rodokanaki, the goods should have arrived by a certain date, at which certain market price prevailed. The owner had made a subcontract to deliver similar goods at a price below the market price. So it's not a self-same goods contract, and that's supported by the passage from Lord Isha that my Lord showed me yesterday, and so on. And then he said Rodokanaki is a decision that in a similar goods subsale, the similar goods subsale is peculiar to the plaintiff. In Williams Agios, the House of Lords approved of this. And again, A had not delivered coals which he sold at 16 and 3. At the time when they should have been delivered, the market price was 23 and 6. But W had sold a similar quantity and description, at 19, and we know the result there is you go to the contract. Why? Because of what he said at the top of the page, you are presumed to go into the market to satisfy the subcontract. You're presumed not to break the subcontract. In an answer, perhaps in a way of answering my Lord Mail's previous, you can break your contract if you want, but you get damages on the presumption you perform it, because breaking it is a novus actus. And it wouldn't have availed counsel to say to Lord Justice Scrutton, but you can break the subcontract. Yes, you can, but you can't get damages on that basis. The House of Lords held the damage was 7 and 3, approving Rhoda Kanaki, and Lord Dunedin said that the defaulting seller is neither mulcted in damages for the extra profit or he would have got forward sale, nor can he take the benefit of the fact that the buyer has made a forward sale under market price. And then he quoted that passage from Lord Dunedin that I have made my submissions on recently, and as the judge says, he quoted it again later on. And in my submission, that was a reference to the fact that in the House of Lords and Williams and Agios, they were claiming an increase in profit. And on one analysis, an increase in profit or liability for damages under the subcontract. So that's remoteness causation, not causation in my submission, but even if it's right, it's obiter, which doesn't apply to our case. Now, he goes on in the middle of page 124 to apply those principles to damage as opposed to delay cases. Now, apply those principles to delivery, sound not damage, and he says, in short, they should all be governed by the same principle because the same considerations apply. He says, perhaps 10 lines up, again, subcontracts do not come into account, for the buyer is under no obligation to use these goods for his subcontract. He may buy in the market and will then be left with goods damaged to a certain extent at the then market price of such goods instead of sound goods at the then market price of sound goods. The difference between the two market prices should be the measure of damages. And again, he's saying the rule should be the same because the market solves everything. Where you can buy and sell substitutes in the market, but of course you can't in a self-same thing case. Then he says, as Lord Dunedin says, the result is, he says it's res inter alios acta, and he quotes again that passage. But the context of it being res inter alios acta is that you can supply yourself in the market, which was the case in Slater, was the case in Williams at Agios, and is, in my submission, the true res inter alios acta in this rule in this case. Then he comes to Wertheim at a third of the way down at 125, and although not technically binding on us, is of course entitled to the greatest respect. And then he says, he says in the middle, it is difficult to see how this fits in with the principles above stated. In the middle of the page, or the lower whole on page 125. And he says at the bottom, the buyer was under no obligation to deliver the contract goods on the subcontract. If he had bought other goods and used them for the subcontract, he would have been left with the goods received at the time when the market price was 42 instead of when it was 70, and would have recovered 27 and 6. And I go on to say, perhaps read the rest, but Lord Scrutton makes the, in my submission, philosophically very valid point that if the contract in Wertheim was for, the buyer was under no obligation to deliver the contract goods on the subcontract, if the subcontract was for generic goods, then the market principle should have dictated a different result. But it is not clear from Wertheim whether Lord Justice Scrutton is right that the buyer was under no obligation to deliver the contract goods on the subcontract. He was right that was the case in Rhoda Kanaki, but it's not clear that he was right in on that case in Wertheim. And he is therefore, in my submission, agreeing with Lord Justice Warrington back at page 119, where Lord Justice Warrington says the only way Wertheim can be right is if it was a case. I'm sorry, not Warrington. Banks at 117. Wertheim can only be justified in a case of self-same goods, says Banks at 117, and Scrutton in my submission agrees at 123 to 124 by saying, 126 to 127, 126, by saying that Wertheim is wrong because it was a contract under which the buyer was under no obligation to deliver the goods on the subcontract. So, in my submission, that is majority of the Court of Appeal at least, and Warrington was not inconsistent, says that two things: that Wertheim is distinguishable because it's delay, but secondly, if it were to be applied to a damage case, it would apply only in the situation of subsale of the self-same goods. And that, in my submission, is philosophically, logically right, because in that situation, you can solve the subcontract in the market.
Well, you won't get any support for the distinction between delay and non-delivery at all from Lord Justice Scrutton.
Exactly.
Because he says exactly the opposite on page 126.
He does. And he says exactly that. I should have myself thought that the principles applied to these two cases were exactly the same, or the same as those applying. But that is Lord Justice Scrutton's view.
Yes.
And in my submission, he is right philosophically, but as a matter of authority, I'm submitting, and this is our respondent's notice point, I'm submitting that this court is either bound to follow Wertheim because of its approval in Williams and Agios, and the distinction in Williams and Agios to the effect that it applies in delay cases, and from the very fact that it is a Privy Council, so that's, you're bound, but you should, on the basis that it is a decision of a Privy Council consisting of 4 law lords, which should not be departed from, I can't remember exactly what the words are, but for good reason, or unless you're sure, something like that. So I will deal with my respondent's notice point now, so I don't have to come back to it. You're bound by Wertheim, alternatively you should follow it. And you're bound by it because it was approved in Williams and Agios, which is the House of Lords. But even if not, you should follow it because it's been approved in Williams and Agios, because it's 4 law lords and approved in Williams and Agios. So, having got that out of the way, can I just say that my submissions as to what the res inter alios rule here are, in my submission, supported by and clearly explained by Lord Scrutton in that case, and also by Professor Tritle in his comment on Bent's, which I've quoted before on the difference between remoteness and causation. It's Authorities, tab 48, page 781. And I needn't...
This is what we looked at yesterday.
We did, but we only looked at the first page, so I'm now inviting you to look at page 782.
Thank you.
And the professor says that the second main difficulty with Bent's, and in Bent's they did allow, that they did reduce the damages because the goods had been passed on to the subcontractor at no liability. The second main difficulty with Bents arises from the refusal of the majority of the Court of Appeal to follow the earlier decision in Slater. And he then mentions Slater, and then, perhaps nearest the first hole, there is no suggestion that the successful difference in the value claim was the subject of ruling had in Baxendale. No reference to that case in any of the judgments. Contemplation of subsales is referred to only by Lord Justice Scrutton in his discussion of Horn, where a plaintiff claimed damages against the carrier for delay in delivery and sought to increase his damages by reference to the loss of profits he suffered, when, because of the delay, he lost an opportunity to sell goods on exceptionally favourable terms. Then over page, it was held that his loss was too remote. So it's the remoteness case in Horn, because the sale was not within the contemplation. Slater's case raised a quite different point, whether a subsale which had been made could be relied on to reduce a claim for loss of value, which was not alleged to be too remote. The issue arising out of that subsale was not one of remoteness, but one of mitigation in the sense further discussed below. And then he discusses the first instance decision, and perhaps at the bottom of the page there's a red line. He criticised the reasoning of Slater's case, this is in Bents, on the grounds that the court wrongly overlooked the basic rule in 53.2 and disregarded earlier cases, in particular Wertheim and Chicoutimi, and said that where it can be seen what the buyer has done with the goods, it's possible and proper to measure his actual loss by reference to that outcome. Now, I am not relying on Bents as such. I am relying on Wertheim as interpreted there. The trouble with Bents is that there were one judge dissented and two gave not only different reasons, but each said that he didn't agree with the reasons of the other. So it doesn't add to the debate, and it would be too deep to get into Bents now. But I rely on the underlying Wertheim. And the 3 lines down, the first, not least because Professor Trattle says that that particular point was wrong. The first of these criticisms is with respect open to the challenge on the ground, already stated in this note, that the issue in Slater's case was not one of remoteness at all, and therefore not within the scope of 53.2. And then he goes on. And then, perhaps it's this, this merits reading in full, but the passage I'm particularly relying on is opposite the higher hole in the page. This is in particular said to be the position where the subsale is of goods identical to those sold under the original contract. But this concept of identical goods conceals within itself an ambiguity. It may refer either to the situation in which the buyer under the original contract has entered into a subsale on such terms that it can be performed only by delivery of the goods bought under the original contract, or to that in which the subsale can be performed by delivery of goods answering the description under the subsale, and the buyer under the original contract then chooses to deliver to the sub-buyer the goods which he has bought under the original contract. In the first of these situations, i.e. the self-same, the buyer has indeed suffered no loss if the terms of the subsale are either such that the goods are in conformity, or such as effectively to exclude liability from non-conformity, with it arising by reason of the original contract. The reason why he has suffered no loss is that he had legally no choice. And that's the submission I was making in answer to my ladies. Yes, well, you don't go into what choice he would or would not have made. What matters is what choices does he legally have. The reason he suffered no loss is that he had legally no choice as to the disposal of the goods, so that they are in his hands worth no less than the full price. Well, I would substitute that no less than their value under the MOA. And this must be so whether the seller knew of or ought to have contemplated the subsale. And that's the point, that contemplation is irrelevant when one's considering causation, and that's the marine star. Hence, in such cases, the rule in Slater does not apply. I so submit. The rule in Slater that you ignore the sum contracts does not apply in the self-same good case. In the second situation, by contrast, the reduction in the value of the goods does cause loss to the buyer, since, as Scrutton said in Slater's case at page 22, he would have been legally entitled, once again, that's what matters, legally entitled to deliver other goods to the person who might be called the sub-buyer, but is not really such, and might have wished to do so had the market fallen. He'd be then left with the defective and less valuable goods delivered under the contract. And that is clear and right, a possible explanation. Scrutton and Treitel together explain very clearly what the res inter alias acta rule is in this area. You ignore subsales of the type where you can deliver something according to the description because of the market, but you take into account specific goods subsales, because in your hands, the only legal thing you can do with them is deliver them onto the subsale. And at perhaps towards the end of page 783, the professor says, the crucial point in both these situations is not whether the parties contemplated the subsale, but whether the subsale was on such terms that it could only be performed by delivery of the goods sold under the original contract. Contemplation of the subsale becomes relevant only in relation to further loss, which the buyer might suffer by reason of loss of the subsale or liability of a sub-buyer or other end user. In such cases, the question is whether this type of loss is too remote. The loss of value cases is whether the alleged loss has been suffered. Now that is impeccable reasoning. It's an impeccable analysis of the true principles. It's supported by Lord Justice Scrutton, and it is determinative of this case.
The problem with it is that one of the problems with it is that there isn't a nice distinction between Category 1 and Category 2. I mean, you can have a situation in which you can say, oh, well, you can perform it only by the same goods as a matter of law, because what is specified in the subcontract is those goods. It's specified by some kind of provision in the subsale. But more often, you will get a scenario where it's a sale by description, but in practical terms, the only available cargo that can satisfy that subcontract happens to be the one for which you contracted. Now, so it may be that it could be performed by goods of the same description in legal terms, but in practical terms, he's got no choice. Now, which of the two does it fall into there?
Well, in your lady's situation, there's no market. So we're not in this area at all. Where there is a market, you've got to use it. Where there is a market and your subsale allows you to use it, you've got to use it. Where there is a market but your subsale does not allow you to use it, then legally speaking, the value of the goods in your hands is their value under the subsale. And in this case, the value of goods in my learned friend's hands was only the MOA, and they got the MOA price. There's an unusually clear academic, principled explanation that is supported by authority, so the relevant part of the Res Inter Aelos Act covers lots of things: insurance, frolics, things that break the chain of causation. But the relevant rule of Res Inter Aelos Acta, for the purpose of at least delayed delivery of goods, is that a contract is only subcontract is only Res Inter Aelos Acta if it can be satisfied in an available market. And even if that is not the rule for non-delivery and damaged deliveries, in my submission it is definitely the rule for delayed deliveries. And my respondent's notice submission is you are bound so to find by avert time. But my primary submission, which I much prefer, is that as a matter of logic, reason and authority, that is the rule based on everything other than avert time. And the criticism of avert time is valid, but only if it was a contract, the subcontract was satisfiable in the market, as Scrutton thought, and as Warrington said. Now, my lord, I need to perhaps I can just submit two final things before giving over to Mr. Board. My lord, Chitty supports the Tritelian Slater analysis, not surprising because this passage dates back to the editorship of Professor Tritel himself. I'll just give you the references. They are Chitty paragraphs 30/1 177.
Which tab's that, just for the notes?
Yes, authorities 46.
Thank you.
And it's the Chitty passages 30-177 through to 30-184. And they come down, they say it's a nice point, but they come down on what I might call the submissions of my clients in this case. The second thing I need to deal with in closing is whether this is a point of law or a question of fact. In my submission, it is a question of law. Although the tribunal said it's res inter alios acta, they did that by applying the rule in Rodo Kanaki. And they are wrong in law to do so because one, Rodo Kanaki is a conversion case, and two, Rodo Kanaki is a case where the subsale was satisfiable in the market. And if you look at paragraphs, so this is a case of them misapplying the test in so finding. They're also wrong in calling it remoteness, but I don't want to get hung up on labels. In effect, the question of law here is it a demurrable plea for a defendant, in my position, to say, in fact, you suffered no loss because of the subcontract, either because in the counterfactual, the subcontract would have prevented your gain, or because in the factual, you recouped your gain from the subcontract. Those two analogous, different fact situations, but same principle must apply. So the question of law could be put this way: is it a bad plea in law for a buyer, for a seller of goods or a late redeliverer of time charter services to say you suffered no loss because you had a subcontract, which meant you had no loss, either in the counterfactual or in the factual? That is the question of law. And in my submission, it is not demurrable. There's no case in which it said that is a bad defense. My learned friend's submission is novel, and it is as much as to say it is demurrable to plead no loss was suffered according to the normal compensatory principle, simply because the grounds on which you say that is a subcontract. And finally, on my part of the case, in my submission, Mr. Justice Bright's material, we don't subscribe to his analysis of Lord Justice Scrutton's judgment, saying that Lord Justice Scrutton's decision depended on foreseeability. In my submission, it didn't. But other than that respect, I invite your lordships to read again and privately nod in agreement with paragraphs 110 through to 126 of the judgment, which
The Pedro.
Yes. I'm sorry, I've pulled it out. It's the core bundle, tab 11, tab 12. 12.
10.
Tab 10, no, this is the judgment. Tab 12, no, ask. Oh, yes, judgment. I beg your pardon, yeah. Tab 10, page 83 through to 85.
Very much.
And as I invite your lordships and your lordship to say that's impeccable reasoning. Finally, so that's it. In fact, my learned friend relied on two other cases, Joyner and Weeks and Biggin. Paragraph 57 of his skeleton, he relies on Joyner and Weeks. Paragraph 60, he relies on Biggin. I would submit simply that those are different cases in different areas. And I would invite you to say, in particular in the case of Joyner, that is a peculiar landlord and tenant rule, which should not be exported anywhere else. And for that purpose, can I just, almost as an amuse-bouche, offer an article by Mr. Gaunt, Casey. Yes, true normand, not an amuse-bouche. Sorry, this is to be added to paragraph 101 of our skeleton, a reference to this. And I would simply invite you to say that in the specialist area of landlord and tenant where this case comes from, Joinson and Weeks is regarded as a special rule of law departing from the ordinary law of contract that created such injustice by giving landlords loss that they didn't cover that it had to be, even as part of the specialist law of landlord and tenant, disregarded. And it really, if you look at the heading, the law of landlord and tenant, which I think is on the second page, the law of contract is flexible. It would award the victim a sum to compensate for what he has actually lost. The law of landlord and tenant is different. It proceeds in two stages. First, bizarrely, in the latter part of the 19th century, it became established as a rule of law that the measure of damages for breach of a covenant to yield up the demised premises in repair at stated term was reasonable cost of necessary remedial works, irrespective of the extent to which at all that accorded with the landlord's real loss. This is generally attributed to the decision of the Court of Appeal in Joyner and Weeks. It said it's a highly convenient rule, a rule of great practical convenience, says Lord Justice Fry. And at the bottom of the page, application of that rule, of course, can readily result in the landlord being overcompensated. Hence, the enactment of Section 18 of the Landlord and Tenant Act 1927, the first limb of which caps the damages recoverable at the diminution of value, and the second limb of which provides that no damages to be recovered if the premises would, at or shortly after the termination of tenancy, have been pulled down, and so on. And it was the lesser of the cost of work and diminution value. And Mr. Gaunt, in trenchant but I submit justifiable fashion, says right at the end, the decision in Joyner and Weeks is replete with ironies, adopted by the courts on the grounds of convenience and simplicity, and because of the late Victorian aversion to expert witnesses, it produced such manifest injustice that it had to be corrected by Parliament. And then the correction itself was worse than the cure, he says. Now, at various stages, my learned friend has submitted, this is a nice, convenient, simple, short rule. Yes, it is. It's unjust. I'm reminded of a dictum from the 19th century where a counsel said, I prefer the swift injustice of the deputy to the tardy justice of Lord Eldon. Well, firstly, the inconvenience of the rule is much exaggerated, in fact, non-existent in modern conditions. We are not, as the Victorians were, totally averse to expert evidence of rates and things like that. And anyway, expert evidence of rates is necessary on the normal measure. But secondly, if the rule is that you are allowed to take into account subcontracts that mean that there is no loss, either because in the counterfactual you wouldn't have made the gain or because in the factual you did recoup yourself, that is not going to cause a starburst of litigation that would not otherwise exist. In the normal case, you're going to have experts on the market rate. All this rule, which is subcontract, the normal rate, the normal measure does not apply, the actual measure applies because you had a subcontract which fixed your measure. All that's going to happen is you look at the subcontract. Because the submission is that you wouldn't have made the normal measure because of the subcontract, your loss is fixed by the subcontract. That will shorten cases in my submission, if anything, and certainly won't lengthen them and certainly won't increase practical convenience. So unless there are questions, those are my submissions, and I'll hand over to Mr. Board on thought.
No, thank you very much. Yes, Mr. Board.
My Lord, may it please the Court, it's my pleasure to address you on the issue of user damages.
Yeah.
This is a subset of ground one of the appeal, and I have 3 submissions to make on it. There is an extent to which they overlap with Mr. Berry, and to that extent I will try and avoid repeating what has already been submitted to you.
Yeah.
The first submission is that damages for late redelivery are assessed according to the contractual measure.
Sorry, damages for late redelivery are
properly assessed according to the contractual measure of loss, and that is, as expressed by Lord Reed in one step, the difference between the effect of performance and non-performance upon the claimant's situation. They are not, by contrast, compensation for a loss of user of the ship. There is no authority for that, and it is wrong in principle. My second submission is that charterers submit that user damages, properly so called, are granted primarily in tort cases to compensate an invasion of a right of property or possession where there has been a wrongful use that prevents the owner from exercising a valuable right of control. So that on that basis, they are not available in a case where there's no invasion of property or possession, and where the interest in performance is purely economic. And those are the words of Lord Reed again in one step. My third submission will be that on the assumed facts of this particular case, even if delayed redelivery in principle were to be considered an example of wrongful use in a broader sense, in this case it was not valuable, and there was no valuable right because the owners had agreed and become under a legally binding obligation not to use the ships in the way for which they now seek damages. So if there was a right of user in this case, it was not valuable, and the damages should therefore be nil. And my lord, I submit that the learned judge was essentially right on all of these points in his judgment below, and that therefore he was right to dismiss the claim for user damages. But before I dive into my first submission, I would make this general point, which is it's unclear to us on our side what the distinction is between late redelivery and other breaches of a time charter which grant user damages. Because if my learned friend is right that using a ship in a manner which you have contracted not to do constitutes a basis to award user damages, one would have thought one would see a mountain of authorities in all types of time charter cases where you wrongly use a ship in breach of contract awarding user damages. One does not see that, and my submission is because damages for breach of time charter are assessed on the contractual measure, not on user damages measure.
Well, the distinction is that other breaches are not the same. A late redelivery deprives the owner of the use and control of his ship for whatever purposes he wishes to put it to when he gets it back. Other breaches don't.
Well, my lady, consider this situation. Suppose that my clients have redelivered on time but in the wrong place. That would have deprived the owner of the use of his ship in the place where it should have been redelivered.
What the use of it?
Well, my lady, it is the use of it, because we had agreed to give it back to him in a particular place, and he has not got the use of it in that place, and is therefore...
He still has the use of it, Mr. Board. Once he gets it back, he can do with it as he pleases. He may not be able to do what he wanted to do with it in the first place, but he can still use it. He has control over it. Whilst it's in your possession, he doesn't have control over what you do with it, and he doesn't have the wherewithal of deploying it as he wishes. That's the distinction I'm putting to you.
My lady, my first point is we don't accept that the ship is in our possession. The ship is in the owner's possession, and the owner uses the ship in his possession to give services to us under the time charter. Our contractual entitlement as the charterer is to give the owner orders to use his ship in his possession to give us services. And so, on a proper analysis, in my submission, the owner judge is right to find this is not a case where there has been a depriving of the owner of possession of the ship. So that's the first point, my lady. But the second submission is
It's clearly right that the owner has possession of the ship under a time charter. That's clearly established. But what he doesn't have is in our case, after the last date for redelivery, is the attributes of possession and ownership, namely the right to dispose of the vessel, however he wishes to do so. So he has possession, but it's no use to him.
My lord, it is of use to him because he is owning charter hire under the charter party until redelivery in fact occurs. And he is continuing to provide services for remuneration for that period.
But he has no choice because, but that's not what he contractually bargained for. So he's effectively being forced to provide those services by reason of your breach.
Well, my lady, the analysis in the cases, and in particular the paragon, is if the last voyage order was illegitimate, in the sense the charterers had no right under the contract to grant it, but the owner nonetheless accepted the order and performed it, the services that he so provided were under the charter party. They weren't under some other arrangement. They're not quantum merit. They are services provided under the charter party. By contrast, if the last voyage order was legitimate, then the owner was contractually bound to accept it and contractually bound to perform it. So, in my submission, it's not quite right to say, and the learned judge was right to say, that the charters have deprived the owner from the loss of use of his ship in a relevant sense, because the owner has still got use of the ship. And the owner is using the ship to perform its obligations under the time charter. And if the owner stopped doing that, the owner would breach the time charter. And so in my submission, although it is right in the general sense to say, and the time charter does indeed say, as my Lord Justice Mells pointed out, the charterers are using the ship. It is using the ship in the sense of giving an instruction of orders to the owner. And it is for the owner to accept or not accept those orders. Now, it may do so in breach of contract, or it may do so in accordance with the contract. Or in the case of an illegitimate voyage, the owner may not have an obligation to do that, but would do it anyway.
Or it may be very unclear whether the last order is legitimate or illegitimate, and the owner doesn't want to find themselves in repudiation of the remaining part of the charter party, and so they accept the order. But nevertheless, the charterer is in breach.
Yes, my lord.
If he doesn't deliver by the latest date.
That's absolutely right, my lord, and that is, in fact, my submission. The charter is in breach of the contract, the promise that redelivery will occur at the end of the time charter period. There's a contractual measure of damages for that breach. But that's it. The owner is using the ship to perform its obligations under the time charter until redelivery occurs. So that the preface, I turn to my first submission as outlined earlier, which is that in a time charter case, the court is concerned with the usual contractual measure of damages. And we see this in the one-step case, and it may be useful to turn that up now because I'll make submissions on it in due course. So that's at tab 39 of the authorities manual. Page 649. The passage I'd like to take the court to is paragraph 36 of Lord Reed's judgment, which is on page 673.
Paragraph
36, my lord.
Page 674.
673, my lord.
673.
Very different case, one step. It was about non-compete clauses, wasn't it, or something?
It was, my lady, yes. The claim in one step was about a non-compete clause, and the claim was for what was formerly Rotham Park damages and is now known as negotiating damages. But what's interesting in one step is, in my submission, Lord Reed's analysis as to how the English law got to negotiating damages as a concept. And that depended, in his judgment, on the first step of user damages in tort cases. But before we go to those, I just want to identify paragraph 36, because it reaffirms the general position for damages for breach of contract. And the last sentence of the paragraph is that what is crucial is to first identify the loss. And in my submission, it's important because immediately above that last sentence, Norby makes the point that it's necessary to quantify that loss as accurately as the circumstances permit. And so the inquiry is the difference between the claimant's situation on the actual facts and the counterfactual, and it is important and necessary to quantify that to the, as accurately as the circumstances permit. And that, in my submission, is consistent with our case that the usual measure reflects the contractual measure, because the inquiry that happens in all of the charter party cases is to identify the difference between the owner's actual situation and the owner's situation he would have been in had it been performed. So turning then to the user damages cases, and this is my second submission. What are user damages as expressed by Lord Reed in one step all about? And we see that starting at paragraph 25 on page 669. So, at paragraph 24, Lord Reed refers to the genesis of the negotiated damages as being influenced by the award of user damages at common law for the tortious invasion of rights to tangible property, and the award of damages on a similar basis for infringements of intellectual property rights. In my submission, that is the category of case where user damages are properly awarded, where there is an invasion.
Sorry, where were you reading from there, please?
Sorry, paragraph 24, my lord. Sorry, I may have said 25 to start with.
Oh, yes. Yes, thank you very much.
And then moving forwards to paragraph 26, Lord Reed deals with the application of user damages to a trespass case, where real property has been damaged or taken by a trespasser. And then over the page at 670, still in paragraph 26, Lord Reed makes the observation that where a trespasser makes valuable use of someone's land, the fact that there is no diminution in its value does not mean that damages are not awarded, because the measure is what a reasonable person would have paid for the right of use. So the remedy is what a reasonable person would have paid for the right which was wrongfully taken. What is the right? It's a property right, or an interference with a property right.
Can the charterer be viewed, not literally of course, but essentially as a trespasser making valuable use of someone else's ship?
My lord, no. Because a trespass occurs when there is no consent. The owners have consented to the final voyage order, either because they are contractually obliged to do so, or because, although they weren't contractually obliged to do so, they nonetheless agreed to do it.
They may have consented to the final voyage order, but they haven't consented to the delivery of the vessel later than the scheduled date.
I agree entirely, my lady. That is a breach of contract for which the contractual measure of damages is awarded. But in my submission, it's not a trespass, in answer to my Lord Justice Mel's question. And I think, if I'm not mistaken, my learned friend conceded in his submissions yesterday that there was no trespass in this case. I may have been wrong about that.
No, clearly not a trespass.
No.
But,
And so one asked the question, my Lord, what...
I was asking whether the logic which enables the landowner to get damages when actually the trespasser walking over his land has made absolutely no difference to him, may apply equally in our situation. And you've said that it doesn't.
My Lord, I say it doesn't. And I submit that because in the landowner situation, the interference is with the property right. Whereas in our situation, the breach was of a personal right, contractual right only. And the law, rightly, does not award damages for infringing property rights according to the same measure as damages for infringing contractual rights. Now, of course, and this is a point which I'll come to, Lord Reid says, if the contractual right does, in fact, also involve an infringement of property, the position might be different. And that's at, forgive me, that's at paragraph 33 of one step, which is on page 672. Lord Reid says, the final sentence of 33, the user principle derived from the property cases discussed earlier is of potential relevance whether the wrongful use of property arises in a contractual or tortious context. In my submission, it is of potential relevance if the wrongful use of property involves an interference with the property right. And whether that happens in the context of a duty of care, for example, imposed by the law of negligence or the contract between two parties, makes no difference. But it's still a principle in my submission which is concerned with the wrongful use of property in the sense of a proprietary right.
Well, do you need to go that far? I mean, I thought your basic point was that there's no wrongful use of the property at all, full stop, whether it's an infringement of the property right or not. You're making lawful use of the property because you're performing the voyage pursuant to a contractual obligation.
Yes, Mary, we certainly do make that submission, and I think on a fair analysis, that's what the judge found below. Essentially, Mr. Justice Bright held that clauses 4 and 8 of the time charter, read together, essentially allowed us to keep using the ship until actual redelivery. And yes, there was a breach in the fact that redelivery did not occur until the date beyond the term of the time charter. But that did not make our use of it unlawful in any relevant sense. Before we leave one step, may I just take the court forward to Lord Reid's conclusions, which start on page 688. Now, these conclusions are obviously focused primarily on negotiating damages because that was the specific claim being made in one step. But there are some points which I submit are of more general relevance.
Yeah.
The first is at paragraph 93, where Lord Reid is concerned with the question of when will a contractual right be viewed as equivalent to a property right? And the court will see what Lord Reid says about that. Now, there's no claim anymore in this case for negotiating damages, but the discussion here presupposes that a breach of a contractual right will not, in all cases at least, be treated as equivalent to a breach of a property right. In my submission, that's entirely consistent with the general principle that contractual damages are assessed on a different test. And then I turn to paragraph 95, which is the passage which the learned judge cited at paragraph 38 of his judgment. The most relevant parts of those in my submission are those which Mr. Justice Bright cited, and those are subparagraphs 1 and 6 to 9. So maybe I'll just invite the court to look at those.
Yeah, should we look at, so you'd like us to read 1 and 6 to 9?
Yes, please, my lord.
Thank you.
So subparagraph 1 refers to user damages, and the examples given there are of claims for debt and conversion and trespass, and I've made my submissions on that. The test according to Lord Reed is, the rationale according to Lord Reed is where the wrongdoer prevents the owner from exercising a valuable right to control use, and should therefore compensate him for the loss of the value of the exercise of that right. But that right to control the use is a proprietary right in my submission, not just a mere promise that something will happen by a certain date. Just to unpack point 9 a little, Lord Reed refers there to where the claimant's interest in the performance of the contract is purely economic. In my submission, pure economic loss here means loss of a similar nature as pure economic loss means in the negligence cases. That is to say, loss that is not consequent upon damage to property, interference with property, or for example, non-pecuniary loss, personal injuries, and so on. It is a loss which purely arises as an economic loss. In my submission, that's the position here. There's been no damage to the ships, interference with the ownership of the ships, possession of the ships by my clients. The loss of it arises is purely economic, which is the loss of the opportunity to obtain a higher rate of charter hire. And so, in that situation, we invite the court in this case to reach the same conclusion as in subparagraph 9. If that economic loss can't be established as having resulted from the breach, the inference is there is no loss. So those are my submissions on one step. I'd like, if I may, just to make some brief submissions on the other cases cited by my learned friends in their skeleton. But
Is this still under your second
point, my lord, yes.
User damages.
Yes, my lord, yes.
Yeah.
And my submission on all of them will be that they are not concerned with breaches of contract, and they are all distinguishable from a case as a breach of contract. Or should I say a pure breach of contract, because there's one case, which is the Penarth Dock case, where there was both a breach of contract and a trespass. So first, my learned friends will learn Stoke-on-Trent and Bass, which is a case at tab 26 of the bundle. It starts at page 378.
Sorry, tab.
Tab 26, my lord.
Thank you.
This case is cited at paragraph 78 of my learned friend's skeleton. but the facts are very different. It was concerned with holding a market, which was said to be in breach of the claimant's right of holding the only market. And my own friends cite this case for the proposition at page 388 of the bundle, which is the sidebar passage of Lord Justice Nichols.
I think I can say that both Fenton and Longton could have done with the excitement of having competitive markets. Yep, first paragraph of Lord Nichols.
Lord Justice Nichols, yes. And that's the proposition my own friends cite.
Yeah.
But what's interesting about that is that on that case, the Court of Appeal unanimously decided not to award user damages on this measure or otherwise. And we see that for example, at page 390, where within the same judgment, Lord Justice Nichols says at about F to H, where his lordship decides that it's not a sound analogy. I'd like the court to read that passage. And Lord Justice North reaches the same conclusion at page 387 of the authorities bundle. Again, letters F to H. And I submit the finding that the analogy should not apply because in this case no loss has been suffered, no substantial damages of any kind can be recovered, is exactly the reason why in this case the court should not, by analogy, apply a tort claim, or tort measure of damages, for breach of contract. So that Stoke-on-Trent, I submit, it goes nowhere in relation to damages for breach of time charters. The second case,
you would say, presumably, that the same issue as Lord Justice Nichols describes at 388 letter D, that is to say, whether there should be a novel application of the principle, is the issue in this appeal. So the question is whether it is a sufficient analogy that even though it is not an interference with a property right in the strict sense for the charterer to delay the redelivery of the vessel, the question is whether it's close enough.
Yes, my lord. And I submit it's not close enough for the measures I've given, but my lord, you're right. We in order for this case to have application, it must be by analogy. The question is whether or not the failure to redeliver by a date in the time charter is analogous to the wrongful interference of property rights. In my submission, the answer is no. The second case my own friends cite is the Penarth, Dock and Pounds decision. They cite that at paragraph 82 of their skeleton.
This is the one the judge distinguished.
Yes, my lord.
And this is tab.
This is tab 17 of the authorities. And the issue in this case
So this is a first instance decision.
It is, my lord. You're not. I hesitate to spend too much
I was
time
going
on
to say, it's not binding on this court,
it. It is not.
technically or otherwise, notwithstanding the eminence of the judge.
My lord, that must be right, obviously, and I submit also that it is irrelevant because if you look at the section of this case on damages, just to pause, the case concerned the keeping of a pontoon within a dock beyond the time for which permission was granted under a contract. And the position was, the court found that there was a reasonable time in which the defendant should move his pontoon, following which he became a trespasser, and in my submission the award of damages reflects that fact. And we see that at page 216, well, I think it should probably start at 215, it's the final paragraph with the sidebarring.
Yeah.
So in my submission, Mr. Justice Bright was right to find this case is about trespass and damages for trespass, and not for just a breach of a contract to do something by a particular time. And if that alone were not enough, and I won't take the court to this, my own friends have included in the bundle a case called Sword Heath Properties and Tebet, which is a landlord and tenant case, which, in case of any interest, Lord Justice McGaw at page 349 explains that Penarth Dock was a case where a trespass was committed. So it is undoubtedly damages for trespass, it is not damages for breach of contract. And there was no trespass in this case. So just to draw this part of my submissions to a close, the position is therefore that my learned friend has not identified any case for any contract in which damages on the tort measure for loss of user have been awarded, where there is no tort, where there is no interference of proprietary or possessory rights. In my submission, that is because it is not the proper measure of damages.
Yeah.
And then finally, my lord, my third submission, which I can take very quickly, and it will be done by the shorter judgment, which is, even if delayed redelivery were an example of wrongful use in a relevant sense, in this case, it was not valuable to the owner. And this is the point my learned friend Mr. Berry has previously made, so I will not dwell on it. But that in this case, the owners have agreed not to use the ship other than to sell it to their immediate buyers. So this is not Lord Halsbury's chair. Had Lord Halsbury entered into a contract not to sit on the chair, the position would be analogous. But there's a distinction between the owner of a property having a valuable right but electing not to use it, and an owner of property not having a valuable right in the first place, and therefore not doing something he had no right to do. In this case, we're in the second of those two propositions. So if Lord Halsbury had contracted not to use his chair and asked me why I had taken it, I would say, you could not have charged a reasonable sum for me to use it because you had no use of it yourself. Now, unless I can assist further on the issue of user damages, those are my submissions.
No, thank you very much, Mr. Board. Right, well, we'll pause there and come back at 2, and I'm sure Mr. Kenny, in the time-honoured way, giving you that additional hour will serve to shorten your submissions in reply. 2 o'clock.
Court file